And I think it's common cause that we are both a staunch supporter as well as a frank critic of the ICC. The issues relating to South Africa's withdrawal and the stated intention to withdraw are centered around the al-Bashir case of 2015, where as I think everybody is aware, the president of Sudan, the then president of Sudan, visited South Africa not as a guest of South Africa, but a guest of the African Union, which was holding its Heads of State Summit in South Africa. Our concern was that the court was being used by powerful non-member states, and that was not what we were expecting in the court. We expected a court that was going to hold human beings accountable for their war crimes, regardless of where they were from. There were also concerns of the fact that all the ICC's prosecutions stem from the African continent, that no investigations into other parts of the world have yet yielded a prosecution. The decision to withdraw wasn't taken in haste. It was also informed by a resolution of the ruling party, the African National Congress, which at its 54th National Conference in 2017 resolved that, and I quote, the conference reaffirmed the resolution of the 2015 ANC National General Council to withdraw from the ICC and stated that South Africa must ratify the Malabo Protocol on amendments to the Protocol on the Statute of the African Court of Justice and Human Rights and encourage the speedy operationalization of the African Court of Human and People's Rights. Now, the position of the African Union also plays a key role, but the AU's position with regards to the withdrawal have shifted, and the latest decision is for the AU, for member states to engage with the ICC around the issues that concern the AU. The events surrounding the al-Bashir case led to the ANC resolution, and as I've mentioned, it was linked also to a ratification of the Malabo Protocol. There are, though, problems with the immunity clause in the Malabo Protocol. That this provision sparked intense debate during the negotiations and the drafting of the protocol. The South African delegation objected to the inclusion of this article, arguing that the court will be deviating from established practice of international criminal tribunals, such as the International Tribunal for the former Yugoslavia, the International Tribunal for Rwanda, the Special Court of Sierra Leone, and the ICC, that does not recognize immunity for sitting heads of state and government, including senior officials. The delegation also argued that the recognition of immunity will undermine the legitimacy, integrity, and credibility of the court and the fight against immunity on the continent. There have been problems with the adoption of the Malabo Protocol. No country on the continent has as yet ratified it, although a number have signed it. And we have, recognizing this, embarked on a process of engagement with the African Union Commission with the aim of amending or reviewing the Malabo Protocol. There are also other factors making it difficult for South Africa and other countries to sign and ratify the Malabo Agreement. This includes the fact that some of the crimes' subject matter jurisdiction are not well defined. So in short, the Malabo Protocol is a long way from being operationalized. As I'd stated, 15 member states out of 55 states have signed the protocol, but none have ratified it. The Malabo Protocol is therefore not going to be a regional apex court for some years. In view of the above, there is a view that South Africa should remain in the ICC based on the reasons that it provides the most effective means to deal with accountability for international crimes where national jurisdictions are either unable or unwilling to do so. The principle of complementarity guides the ICC as a court of last resort and safeguards national legal sovereignty.